Hello, thank you for joining the HOA forum today. This is the Colorado HOA Information Resource Center. We are doing an HOA forum today on meetings, connecting with homeowners in your community. And I'm very glad that you decided to join us. I hope you get some information out of this, some good information, and hopefully you'll learn a thing or two about meetings and kind of what's going on and or what's supposed to go on in HOA meetings. Those of you who don't already know me, my name is Nick Altman. I'm the HOA Information Officer with the HOA Center. I also have Amanda and David here today with me. Amanda Lopez, she's our kind of our registration guru. She handles all of our, or most of our registration inquiries. Hello, Amanda, how you doing today?
Hi, good afternoon, guys, and thank you all for joining. Thank you, Nick.
No problem. And then hello, David. David Donnelly, the manager of our Education, Communication, and Policy program. Thanks for joining.
You bet. Absolutely. Thank you, everyone, for joining us. We've got a good attendance today, so I'm excited about this topic, and I'll pass it back to Nick to get going. All right. Thank you again.
Yeah, so thanks again. And Amanda and David, I'm going to leave it up to you whether you want to turn your videos on or off, but they're going to help with questions today and just generally having a good discussion. So for your information, we'll be using the Zoom interface. As you guys can see, the chat function below is enabled. So throughout the course of this presentation, feel free to post your comments and questions and we'll do our best to answer them. Just so you know as well, this presentation will be recorded and uploaded to our YouTube page. So don't make fun of me too much, please. So I'll likely be talking for about 30 minutes or so, and we'll devote time after to answering any questions. But if there are any burning questions throughout, we'll just pause the presentation and we'll get to those questions. But I know it can be difficult to have an engaging presentation when you, the attendee, is not able to speak. So throughout today's discussion, I'll try and incorporate some polls and fun quizzes that we can all participate in. I hope you enjoy them and maybe even try and learn a thing or two. So with that being said, let's actually see who is joining us today. Let me see if I can launch this poll here. All right, so you should see a poll on your screen. And we just want to know what party you're representing. Are you a homeowner? Are you a member of the board of directors? Just give it 10 seconds here. Thank you very much for participating. We appreciate it. All right, let me try and share those results with you all. Got a lot of homeowners and a lot of board of directors. So thank you very much. All right, let's move on. All right, just a quick disclaimer, like always, the information provided during this presentation is for educational purposes only. It is not meant to provide, nor should it be construed as legal advice. Any legal questions you may have should be directed to a qualified attorney licensed in Colorado. All right, and then what do we do here at the Information Resource Center? I know you guys have seen this before, but it's worth repeating. So what we do is we provide information to homeowners regarding their basic rights and responsibilities under the Colorado Common Interest Ownership Act. We gather, analyze, and report information through complaints and HOA registrations. We create resource materials, education, and forums such as this. We provide a website with information for the public. We register HOAs pursuant to Section 401 of CCIOA. And we provide an annual report to the state legislature. What we do not do is mediate or arbitrate on behalf of homeowners, board members, or community association managers. We do not act as a regulatory program. We don't provide legal advice. We don't investigate or intervene in disputes that might arise between homeowners or their associations. We do not assess fines or penalties. And finally, we do not enforce an HOA's failure to register. So CIOA is abbreviated CCIOA, and that's, again, that stands for the Colorado Common Interest Ownership Act. That can be found in sections 38-33.3-101 through 402 of the Colorado Revised Statutes, CRS. That's what CRS stands for. That's what we refer to when we say CIOA. I wanted to throw a quick slide here on how you may view the latest version of CIOA online. I know that's a lot of text. I'm not going to go over each step, but if you're watching on YouTube, feel free to pause the video and follow those instructions. But if you haven't already checked it out, I encourage you to visit the Colorado General Assembly's website and check out the law for yourself. You know, flip through there, breeze through it, share it with your community members, with your board members. Let them know that it's available to look at. And throughout the year, it's updated as new law is passed. And I believe it's in October of each year that the online version is updated. So that's just for your reference right there. All right, so just kind of a high level overview of what I'll be talking about today. What is a homeowners meeting? How frequently should they be held? Are there any specific requirements that should be known? What about meeting notices? How soon should those go out? And what should be included on the official notice? What are meeting minutes and the meeting agenda? Importantly, what does state law have to say about all of that? We'll go over a few scenarios in which I'll ask you to figure out if a quorum has been met or not. So put on your thinking caps today. And then finally, I put together some best practices and pro tips that should hopefully help you run a great HOA meeting. Get into it. So what is a homeowners meeting? So HOAmanagement.com defines a homeowners meeting as a general meeting of sorts for the entire HOA membership. So it's at these types of meetings where the HOA board of directors addresses concerns in the community. They'll present the annual budget, they'll review committee reports, and typically hold elections. Importantly, community members are allowed to vote on issues impacting the community and other items that may be on the agenda. And the homeowners meeting is intended to bring people of the community together and generally just foster a sense of togetherness and unity. So is there more than one type of homeowners meeting? So I'd like for you all, if you wouldn't mind, to just put in the chat if you're able, what do you think are the main types of HOA meetings that you'll commonly encounter in your standard HOA Colorado community? What do you think are the names of the meetings that you'll encounter? Got an annual meeting, annual budget meeting, board meeting, budget meeting, special meeting. Town hall. So yeah, so there are generally two types of main meetings. You have your annual homeowners meeting, the first and most well-known type. So it's called the unit owners or homeowners meeting. So that's the type of meeting you'll see most of your neighbors at. They'll be able to vote, like I just said. It's generally the most important type of meeting. And here you'll see most of the decisions impacting your community being discussed and voted on. So the next major type of meeting is the board meeting or board of directors meeting, or you might also hear it referred to as the executive board of directors meeting. So the board meeting is where the executive board makes decisions that impact the community. The topics of discussion usually follow a more strict protocol or agenda compared to the unit owners meeting. Issues to discuss are usually already agreed upon in advance in order to make the meeting as effective as possible. Boards they might make decisions on whether to buy a new playground, for example, or hire a new trash collector, or maybe they're trying to figure out when they want to open the swimming pool for the summer. So an important distinction here between the two types of meetings is that unit owners may not vote in board meetings, although they do have a right to speak and be heard before an issue is voted on. The unit owners cannot vote in the board meetings. Only the board themselves can. So within both types of meetings are two important mechanisms available in HOAs, and those are called special meetings and executive sessions. So the reason I wanted to include a visual here like this is because both a unit owners and a board meeting may call a special meeting. And also the board may go into an executive session in both the unit owner or board meeting. I hope that makes some sense there. So essentially a special meeting is just an unscheduled meeting whose purpose is to discuss a particular issue. It can range from a variety of things. An executive session is a closed door gathering of the executive board where they'll usually discuss private matters that shouldn't be disclosed to the general membership base. Importantly, executive sessions may not be attended by the unit owners. They're typically closed doors, or they should be closed doors. I'll get more into what may be discussed in an executive session a bit later. But for now, let's talk about each one of these meetings in a little more detail and see and also what CCIOA has to say about them. So for these next few slides, I'm going to show you the actual language used in CCIOA, but I'm not going to just read it straight off the slide because that's kind of boring, and you can look it up yourself and read the law for yourself. But what I'm going to do is break apart each section and kind of talk about it on my own, how we interpret that, and importantly, what are the important parts of CCIOA? Like what should you pay attention to and follow to ensure that you're holding good meetings, good HOA meetings. So first thing, state law says that the annual homeowners meeting must occur at least once per year. So can you hold more than one homeowners meeting? Well, sure. I know the homeowners would probably appreciate it. Heck, you might be dying to hold that potluck or a community barbecue, and you just love gathering all the community members together. But must you hold at least one? Yes, that's the answer. So this next part, we have established homeowner meetings must occur once a year. So what about notice requirements? How far in advance do we need to notify the homeowners? Well, state law says somewhere in between 10 and 50 days in advance. So, somewhere in between 10 and 50. So under 7 days, that's probably too soon, or actually that is too soon. 2 months is too far out. It's got to be somewhere in between 10 and 50 days. The HOA should have a list of member mailing addresses, and this is where the notice should be mailed out, prepaid by US mail. We frequently get the question, well, can we just email the meeting notice? Let me get to that in a second. In addition to mailing out the notice must also be physically posted somewhere in the community where people can see it. If you've searched hard and you just can't find a feasible place to post the notice, you probably don't need to worry about it. But for example, if there's a community bulletin board or maybe a common area mailbox where people go to pick up their mail, and if you're able to post a notice there that won't get blown away or drenched in rain, that could be a pretty good place to post a conspicuous notice or somewhere that's easily identified. All right, so the notice should include the basics like the time and place of the meeting, as well as the general nature of any action items to be discussed or voted upon. And then regarding email, state law encourages the use of email, and that's basically all it says. So if the HOA has a valid email address and a unit owner specifically wants the meeting notice emailed to them, then the HOA should send it by email. The more you can communicate with your homeowners, the better. However, it doesn't say email is mandatory or the unit owners must opt into an email. It just says the use of email is encouraged by state law. All right, regarding board meetings, the first thing you should do is check your HOA governing documents, because most likely you'll find all the details in there about how often they should be held, the time, the place, the setting, etc. However, there's no express state requirement as to the frequency of board meetings. Generally speaking, the board may call as many meetings as it needs in order to meet the goals of the community. So there's the statute citation for you as well, just so you know I'm not making this stuff up. So who's actually allowed to attend a board meeting? So CCIOA says all members of the association or their representatives may attend board meetings. Who's a representative of a member? Well, it could be anyone. It can be a family member, a friend, a colleague. Maybe you want your tenant, maybe you're a landlord and you want your tenant to attend on your behalf. They could all be considered designated representatives, and they would be able to attend those board meetings in your stead as a homeowner. Granted, there's some best practices, like you should maybe have that in writing, and you should maybe submit that to the board before the meeting, just so they know who's going to attend. But it's always a good thing to have that in writing. Does CCIOA say anything about board meeting agendas? All it says about board meeting agendas is that they should be made reasonably available for examination by all members of the association or their reps. So it says nothing as to what items should be included on the agenda or how a concerned homeowner might petition the board to include a specific item on the agenda. All it says is that they should be made reasonably available for examination by all members of the community. So again, keep in mind, your governing documents will probably contain their own provisions about board meeting agendas, but for the purposes of this presentation, I wanted to include these sections of CCIOA. That way you can refer to them on your own if any questions come up. Let's see if I can get a poll here. All right, I got another one on the screen. The question is, how many unit owners typically attend your board meetings? How many unit owners typically attend your HOA's board meetings? All right, let me see if I can share these results. The vast majority is less than five unit owners. I know that's, we hear that a lot. That's always a problem to get the community engaged and involved. We also have some HOAs out there, greater than 25 unit owners. That's great that many people show up and that they're interested and involved in what's happening in their community. Okay, just moving on here. All right, so earlier on, I mentioned there are two important mechanisms available within HOAs. So let's see what state law has to say about special meetings. So here's a citation. So must the unit owners or board of directors call a specific number of special meetings throughout the year? Well, no, there's no frequency requirement. They may be called anytime, or they may never be called. It really just depends on the goals of the community and what the issues are. So a special meeting may be called by one, the HOA president, by 2, a majority of the executive board, or by 3, and I like this next one because it's not simple, unit owners having 20% or any lower percentage specified in the bylaws of the votes of the association. So does that necessarily mean 20 people? No, it might not. Again, check your documents for the specific requirements, but what that means is you might have one unit owner in your community who has a greater share of votes than the other unit owners. So that's something to keep in mind when the unit owners are considering calling a special meeting. So if a special meeting is called, the same notice requirements as the annual homeowners meeting must be followed. So recall that's somewhere in between 10 and 50 days in advance, the unit owners have to be notified, and the notice must be physically mailed to each unit owner's mailing address, and if possible, posted in a conspicuous place, if you recall. So oddly enough, there's no time frame for electronic notice of the annual homeowners meeting or the board meetings, but CCIOA provides for an at least 24-hour notice prior to a special meeting being held, if such means are available. And again, that's Colorado Revised Statute 38-33.3-308 meetings. All right, so moving on here. Again, how to call a special meeting. Again, I mentioned this just earlier or just right now, but I wanted to provide a graphic here. I'm a visual learner, so it kind of helps me understand when I can see visuals. But again, in order to call a special meeting, it can be called by the HOA president, a majority of the executive board, or unit owners having 20% of the votes of the association. All right, so let's talk about executive sessions now. So as I mentioned previously, an executive session may only be called or entered into during a regular or specially announced meeting. So in other words, the board can't just decide to get together and meet for an executive meeting because they feel like it. It must occur during a regularly scheduled meeting of the association owners. Or a board meeting. So if an executive session were to happen, it must be announced ahead of time, like the chair or whoever is deciding to enter into it must actually state we are entering into an executive session, and they must also state the general topics that are going to be discussed. So an important component here is only the general topic should be stated, not the particulars of the discussion. What does that mean exactly? You might not want to discuss matters that could be in violation of someone's privacy, or just general legal matters that are confronting the association. The matters to be stated should just be a general format, a general topic of what's going to be discussed. So this next part I'd also like to emphasize on the screen there. It says no rule or regulation of the board or any committee thereof shall be adopted during an executive session. So a rule or regulation may be validly adopted only during a regular or special meeting, or after the body goes back into regular session following an executive session. So a lot of the times we hear here at the HOA Center that the board of directors adopts policies. They go into an executive session, they'll vote to adopt a policy, then they'll leave and they'll never say anything about it, or there won't be any transparency to the rest of the community on what happened. So that's kind of a big no-no. You want to avoid that. And also remember too that anytime a vote is taken during a board meeting, the members should be allowed to speak on that issue. Keyword before a vote is taken. So that's just something good to keep in mind. I just said that, the general matters, and this is laid out in Kiowa, sections A through F, and let me get to that here in a second. One last thing I was going to mention, House Bill 22-1137 allowed for the board or the participants of the executive session to make a vote on whether to send a delinquent unit owner to collections or not. So they can still vote, they just cannot adopt a rule or policy in that executive session. I know I'm talking about executive sessions a lot here, but it is an important topic. Let's get on to what can and cannot be discussed within these sessions. So board members might talk about the community association manager's contract, for example, or whether they want to continue whether maybe they want to let go of the accountant or any other matter that might involve promotion, discipline, or dismissal of an officer, agent, or employee of the association. They can speak with their attorney on matters deemed attorney-client privilege. If maybe there might be a pending lawsuit in the community and they just want to talk to their attorney about it, some of the details. Perhaps they want to talk about a police report that might have recently been filed in the community and any investigative proceedings. Say your HOA has a security committee. Maybe they want to talk about the details of their latest findings or what's happening in the community. Moving on, the board might want to talk about a court order of confidentiality or maybe a gag order, for example. For those of you who don't know what a gag order is a legal order from a court restricting certain information from being made public. Similarly, they might just want to get their attorney's legal opinion on a statutory requirement. And this next section is important here because I do believe I already discussed it, but the board can vote on whether they want to send a delinquent unit owner to collections. If this is something that your community is considering doing, we recommend talking with a licensed attorney, as we can't provide legal advice here, but it's good to know that it's there regardless. And lastly, the last thing that you can talk about in an executive session is just to go over maybe legal counsel's written recommendations before calling, say, for a vote in an open board meeting. Maybe they just want to clarify a few things, make sure that maybe the ballot is correct or votes were taken in a proper manner. Anything that really involves legal advice being imparted upon the executive board. All right, let me give another poll here, just so I can take a break from talking for a second. All right, do you think your board does a good job of allowing unit owners to speak and participate at meetings? So yes, no answer there. Hopefully most are yes. Hopefully most of the answers are yes. Looks about 75% of you said yes, and 25%, maybe I don't know, maybe you want to take a look at maybe allowing unit owners to speak more, bring up their concerns during your meetings. All right, moving right along here. Okay, so one more type of gathering, and I'm going to use the word gathering here because a working session is not considered to be a meeting in the eyes of the law, but it is something to be aware of because sometimes they happen. So basically what a working session is any gathering of the unit owners or board members, or maybe it could be the community manager or even the attorney, but no votes are happening and no official HOA business may be conducted at these meetings. So really it's just an unofficial, I guess I could say casual gathering of sorts. And it's not expressly laid out in Kiowa, but it's still just something worth noting. So because they're unofficial gatherings, unit owners do not have a right to a notice of these working sessions, and minutes are not required to be taken. So just something to point out there. All right, so we know that unit owners have a right to participate in meetings. That's a granted. But what exactly does state law actually say about that? So let's find out here. So a unit owner may speak regarding an issue. So best practice is for the board to allocate a certain amount of time. It says right there, at an appropriate time determined by the board, but before the board votes on an issue under discussion, unit owners or their designated reps shall be permitted to speak regarding that issue. It's worth just kind of hitting that one home over and over again. Best practices here, right? So the board might want to allocate a select amount of time for each individual to speak on each issue ahead of time. So say, you know, oh, we have a fence that needs to be fixed, or the swimming pool is gross, or we have rodents in the building. Let's make sure that we don't allow more than 3 minutes per unit owner to speak on this issue. So kind of make sure that that's mentioned before the meeting starts, just so expectations are understood and laid out. I'm sure most, some of you, I don't know most, but some of you might have experience with loud and unruly homeowners who might tend to hijack the meetings, if you will, and kind of make things miserable for everyone. So it's for this reason that those expectations should be established upfront about how long people may speak. It doesn't say there's no specific time. It just says the board shall place reasonable time restrictions on persons speaking during the meeting. So you might ask, well, what's reasonable? I just said, you don't want someone to take over the meeting. You don't want the meeting to last for 3 hours or 5 hours long into the wee hours of the night. But unfortunately, we can't really say what's reasonable. That would have to be determined by a judge in a court of law. But this is what CCIOA has to say about that. So, moving on. I don't know if there's any burning questions in chat, David or Amanda, that you noticed. Anything worth mentioning at this point?
I've been answering some of the questions as they've been coming through, but one question that's out there right now sort of pertains to again, that opportunity to be heard that you were talking about a little bit earlier, and also how different homeowners can be heard at these meetings, and so I think something to kind of that might be important to convey to everyone here today is that while every homeowner has the right to be heard, and that right is before a board votes on an issue, it is subject to that reasonableness, Nick, that you were just talking about, which might, and you very well might be getting to this in a bit, Nick, but the idea that a board can adopt first off develop, but then adopt a governance policy that pertains to the conduct of meetings is a really important way to manage the expectations of everyone, both board members and homeowners alike. In that conduct of meeting policy, you might say everyone is allowed to speak for 3 minutes on that topic, on their position or what have you. So, but having that written out in a policy is a really good practice for all of you to consider in your communities.
Awesome, thanks, David. All right, let's talk about quorums. So, have any of you ever wondered if a certain amount of owners are needed in a meeting in order to make its proceedings valid? That's a pretty good question, right? Like, oops, sorry, my slide skipped there. What if you're the only one sitting in your HOA's board meeting? Are the decisions made by the executive board still valid? Do you need more people in order for votes to be considered legal or actionable, or policy to be legit or real? Well, that's a great question, Nick. I'm so glad Nick is asking these questions. So first of all, what is the definition of a quorum? So Oxford Dictionary defines quorum as the minimum number of members of an assembly that must be present at any of its meetings to make the proceedings of that meeting valid. So what's that mean exactly? At your HOA meetings, if the necessary number of owners are not present, then any vote or action taken is legally invalid. So the meeting may as well have never occurred. What does our friend CCIOA have to say about quorums? So it tells you first to look to your HOA governing documents, because most likely the requirements will be set forth there. Most HOAs will already have this spelled out, but there are a couple, occasionally you'll run across an HOA, maybe it's an older HOA, maybe it's been forever since the policies have been updated, or they've just been changing so many things in the bylaws that they just don't know what the quorum requirements are. So if that's the case, then this is what CCIOA says: for any meeting of the association, the specific requirements for quorum will first be found in the association's bylaws. If the bylaws are silent on quorum requirements, then a quorum is deemed present if persons entitled to cast 20%, or in the case of an association with over 1,000 unit owners, 10% of the votes which may be cast for election of the executive board are present in person or by proxy at the beginning of the meeting. That's a lot of words to say right there. So what does that mean? So 20%, if persons entitled to cast 20%, mind you, this isn't the same as 20 people. This is saying persons entitled to cast 20% of the votes which may be cast for election of the executive board. So whatever your HOA governing documents define to be a person who may cast a vote for election of the executive board. You'll just have to take a look at your governing documents to see what that means exactly. But generally speaking, it's probably 20 people, probably 20 people. And then key word here, in person or by proxy. So again, the homeowner or unit owner can issue a proxy. They can grant a proxy to someone to bring to the meeting, and then that individual has the legal capacity to act on that person's behalf to make quorum requirements. Granted, this is if your bylaws are silent on the matter. Okay, so that was the requirement for any meeting of the association, but what about quorum requirements for board meetings? I know that's kind of an interesting word play there, but unfortunately, CCIOA loves to play with words. So for board meetings, this is what it says. Unless the bylaws specify a larger percentage, a quorum is deemed present throughout any meeting of the executive board if persons entitled to cast 50% of the votes on that board are present at the beginning of the meeting or grant their proxy as provided in, get ready, here's another Colorado law. This one's called the Colorado Nonprofit Corporation Act, or CRS section 7-128-2054. I wanted to include that there just so you know that there is another state law that speaks to certain association, I guess, matters of interest, and this is one of them, executive board meeting quorum requirements. So again, what does that mean? That says that doesn't necessarily mean half of the board. It just says, a majority of the board. It just says persons entitled to cast 50% of the votes on that board. So, what your board of directors has 7 people, maybe it has 5 or 7 people, 50%, that would be half a person, right? So that doesn't make a whole lot of sense. So generally speaking, it is the majority of the board has to be present in order for that board meeting to be valid. Okay, we're gonna play my favorite game. This one's called, Is There a Quorum? This one airs NBC at 9 o'clock on Saturdays. No, I'm just kidding, it doesn't, but I'm thinking of maybe starting my own game show. So what I'm gonna do is I'm just gonna put a question here. I'm gonna give you guys a minute to read it. Or actually what I'll do is I'll read it out loud and then give you a minute to try and figure out, yes, is there a quorum, or no, is there no quorum? So let's get started here. An HOA has 50 unit owners who may cast a vote for election of the executive board. The HOA governing documents do not contain any quorum requirements, i.e. they're silent on the matter. The annual homeowners meeting is scheduled to start at 6 p.m. tonight. How many unit owners are needed here to make quorum? You can just put it in chat what you think your answer, what you believe the answer to be. Again, you have 50 unit owners. What did I just talk about? Let's see if you guys are paying attention. Tens, we got some tens. 20%. So you need 20% of the unit owners. Yeah, you guys are right. The correct answer is 10. Where's my, there it is. Correct answer is 10 because 20% is needed in this particular instance. The governing documents are silent, so it's going to revert back to CCIOA, which states you need 20% of the persons entitled to cast a vote. All right, are you ready for question number 2? An HOA has 200 unit owners. And by the way, this is going to get a little more difficult. This is an intermediate level question. The HOA bylaws state 25% of unit owners must be in attendance at the beginning of the meeting at all association meetings in order for a quorum to be met. Proxies may be used if a homeowner is unable to attend. There are currently 46 members present and 3 executed proxies have been given to the secretary. Is there a quorum? Okay, maybe that was a little easier than I thought it was. So yes, the correct answer is no, there's no quorum here. Why? Because there's not 25% of unit owners represented at this meeting. How many additional unit owners or their representation needs to be represented at this meeting in order for, you guys are on it, 1, correct? Amazing. All right, last one. This one's kind of long, but let's just get it. Let's get it. The executive board of Nicholas Jokic Homeowners Association. I hope you guys see what I did there with Nicholas Jokic. Is about to meet for its monthly board meeting. This is a particularly apathetic community with only 16 unit owners out of 400 in attendance. There are many important issues that need to be discussed, including getting a new insurance carrier and installing a new $5,000 security gate. HOA member Carlos is surprised to learn 2 board members are absent, even though 3 out of 5 are still present. Is there a quorum at this executive board meeting? Yep, correct answer is yes, because persons entitled to cast 50% of the votes on the board are present at the beginning of the meeting, which should be, technically speaking, it's 2.5 out of 5, but you can't have half a person. So 3 out of 5 satisfies that requirement. Okay, so briefly, I'll talk about agendas and minutes. So believe it or not, there's no state requirement about what a meeting agenda should look like. However, here's what it says. If there's an agenda, so keyword, if there's an agenda, its items must be stated on the meeting notice. That's it. That's all it says. Most HOAs do have agendas they send out. Sometimes, I don't know, maybe a special meeting might be called and, there might not be an agenda. So if there is no agenda, then there's no requirement. So typically, most agendas will say topics like proposed amendments to the declaration or any proposed budget changes. Maybe the community is thinking of issuing a special assessment in the coming weeks because of, I don't know, the skyrocketing cost of insurance in the state. Maybe it might include a proposal to remove an officer or member of the executive board. Excuse me. So again, there's nothing special about board meeting agendas either, except that they should be made reasonably available for examination by all members of the association or their written designated representatives. So that's what the state law requirement says about executive board member agendas. Only that they shall be made reasonably available for examination. What does that mean? Again, we can't say what does reasonable mean. That'd have to be up to a judge. But if we think about it, I mean, if the agenda is only, you have to have like a Alienware computer to access the database of the association that requires, I don't know, a hacker to hack into the mainframe. That might not be, you know, a reasonable way for members to examine the agenda, but good to know that that's what it says. Again, the state loves it when you provide notices and agendas in email format, although it doesn't require it. It's just their associations encouraged to provide all agendas in electronic form, in addition to the mandatory printed form. Okay, so just like agendas, there's no state requirement as to the content of meeting minutes, really like what needs to go into minutes or what is a requirement, except that HOAs shall keep as permanent records minutes of all meetings of the unit owners and all meetings of the executive board. Let me take a breath here to catch my breath. And a record of all actions taken by the unit owners or executive board without a meeting, and a record of all actions taken by a committee of the executive board. So maybe the executive board has created a committee on landscaping design, or most likely you'll have a committee on architectural review requirements. Any decisions made by those committees on behalf of the board, there must be minutes, plain and simple. There must be minutes, and there must be a permanent record of those minutes available to unit owners on request. So keep in mind, anytime an executive session is held, whether at an annual meeting or a board meeting, minutes must be kept and include, I already mentioned this, the general subject matter of the discussions that were held in that executive session. So if we recall, an announcement must be made that the board's going into an executive session. They must state the general topics of discussion that they're going to talk about. And then once they exit that meeting, there must be a record of minutes of generally what was discussed. Again, you probably shouldn't include personal sensitive information, just the general subject matter of what happened. So real quick, what are some best practices about maybe what should be included in minutes? Agenda items, any discussions that happened, actions that occurred, motions to make to bring up a specific issue or to vote on something. Maybe the secretary or whoever is doing the minutes, maybe they want to say who spoke on that issue, what was the outcome of that discussion, and maybe how long was the meeting and where was the meeting held. Just keep it factual and refrain from including any personal opinions. Okay. All right, almost done here. So I wanted to include some helpful reminders about just some of the key concepts here. So the unit owners meeting, again, remember that's the same thing generally referred to as the annual homeowners meeting. The quorum requirements, bylaws first, check your bylaws first. If they're silent, then 20% of unit owners, or 10% if your HOA has greater than 1,000 units. The agenda, all it says, or all that's state requirement, items included. If there's an agenda, the items on that agenda should be or must be included on the meeting notice. Minutes, permanent record must be kept. Switching over to board meetings, same thing, except slightly different. Quorum, 50% of the board members have to be present. The agenda shall be reasonably available for examination by the unit owners ahead of time. In the minutes, a permanent record must be kept. Okay, almost done here, and then we'll try and answer some more questions. Let me just, one last poll. Actually, let's skip the poll. Let's just get straight into the pro tips. So number one, don't forget to follow your governing documents. So we can't stress this enough because a lot of the times the answer you're looking for is in your HOA governing documents. Number two, make sure a quorum has been established before conducting any sort of business. If you're not sure, maybe you don't want to have the meeting. Maybe you want to double check and just make sure that that enough people can attend in order for your important business items to be addressed. Can you still talk, can you still meet and talk about issues? Well, sure. But just in case an issue were to ever arise later, where, maybe an attorney or possibly even a judge might get involved in a dispute, you'll want to make sure that that meeting had met its particular quorum requirements. Spend some time planning and improving the agenda ahead of time. A well-organized agenda makes it so that expectations are laid out and ahead of time. Everybody knows what the issues will be. They'll have enough time to research the issues. Maybe they want to talk to their neighbors about it. If there's, if you have a bad agenda or kind of a poorly prepared one, that's kind of when issues tend to arise and the conflict ensues. Allocate a set amount of time per issue. As a board, try and agree on how much time do you want people to talk. Maybe it's 5 minutes or 10 minutes might be a little much, but agree on that ahead of time so that and that your homeowners know as well. Submit questions to the board. If you're a homeowner, submit your questions ahead of time. Try not to set them up as like a firing squad where you're just attacking them and you're like, oh, why didn't you address this? Why didn't you address that? Blah, blah, blah. Or what's going on with this issue? See about maybe, communicating with that person so they can research CCIOA. They can read the HOA governing docs. Throw them a bone, allow them the opportunity to look into your concern. If you're the board and you're not sure, hey, maybe try and contact the HOA Information Resource Center. Maybe they might have some good information for you, or at least communicate with the unit owner. Tell them, hey, let me look into it. I'll get back to you, and try and give them a time, like 2 or 3 days. Don't just say you'll do something and then not do it. That's kind of maybe one of the worst things you can do is not communicate or give them bad information. Next tip here. So this one's important too, but try and refrain from holding meetings at somebody's house, as this can be awkward and intimidating. Maybe not everybody wants to try and talk over your 120-pound Rottweiler who's gnarling at them as they try and inquire about a policy or something like that. Maybe try and hold the meetings in a neutral location like a library conference center or the rec center, for example. You might find that those are actually cheaper than you think to rent out just for the evening. Discuss the conduct of meetings policy before the meeting starts, or send out important key concepts to everybody just so they know, hey, listen, this is what we're going to talk about. This is the conduct that we expect everyone to adhere to. Even print off a copy of the conduct of meetings policy, put it in a big old binder on the center of the conference table. That way, if anyone challenges you, you can just be like, hey, there it is right there. That's the policy. If the association doesn't have a community, we'll give our community association managers some highlight here. But if your HOA doesn't already have a community association manager, maybe they want to consider hiring a manager to professionally run these meetings, because they're not easy. It's not easy to run a good meeting, and some of the management companies that we've seen, they've done this a long time and they know what they're doing. So just something to consider. All right, so real quick here, where can you go on our website to find the HOA forums? It's on the drop-down menu, you expand education and outreach opportunities, and the big old red arrow there, there's a link for the recent HOA forums presentation. That includes the YouTube video as well as a copy of the slides that you can download. Here's where you can go to access our frequently asked questions, which is a great resource. Tons of questions and tons of information just at that link alone. Where can you go to see board member education resource page? Again, right there. Lastly, 2022 legislative updates is right there. And yes, we will, 2023 legislative updates will be added soon. So stay posted with that. All right, so I think I'm officially done with my presentation. Here's our website, the link to our URL. And there's our email address. Let me just repeat that. Dora _ and I know you can't see the underscores in this slide, but Dora _ DRE _ HOA inquiries at state.co.us. The underscores are where those two spaces are. And for your information, the underscore is the key on your keyboard that's to the right of the 0 at the top. You have to do a shift, you have to hold down shift. And that line right there is the underscore. Great, all right, let's do some questions.
Hey there, Nick, this is David. A couple great questions have come in, and some of which we've been answering in the chat here, but a couple that are probably worth revisiting for you. A couple people have asked regarding how long minutes need to be retained. Can you answer that? I mean, so basically, we have a meeting next month, and what happens 30 years from now?
Yeah, actually the slide here, meeting minutes there shall be a permanent record of meeting minutes. I hope that answers the question.
Another question that's a little bit off topic, but still related to these meetings because it pertains to elections and voting. One of our viewers asked about if there are multiple owners of the same property, does each owner get to vote, or is it just one per unit per household? I'm gonna actually I'll field that question, Nick, if that's okay with you. And the question really depends. It depends on your governing documents. I've spoken with some individuals that have a single family homes in their HOA, and the governing documents allocate 2 votes per property, and they can and those governing documents specifically allow that community to say, I want to vote once for this and once against this. Maybe it's a husband and wife that live together, they disagree with each other. Yeah, they're certainly just canceling each other's votes out if they do it that way, but that's their prerogative. They're allowed to do that. But most communities say that you can only vote your interests, whatever that might be. It might be 1 vote, might be 2 votes, might be 1.25 votes, which is what I used to have in my community. And that was because in my community, we were allocated votes by the amount of square footage of each of my units. So the guy that lived next to me had 1.15 votes because he had about 10 square feet less than I did. But the allocation is determined by your governing documents, particularly by your declaration of covenants, conditions, and restrictions, your CC&Rs. And so most communities say you cannot split your votes. You can't vote for and against something. And then following that one step further, before we move on, is what if I own my property with my partner or both my brothers, whatever the case might be? They're going to say there might be 3 owners. All 3 of us come to the meeting. In most communities, me and my brothers, we need to decide how we're going to vote and then we vote that together. We don't each get a vote just because we're all at the meeting. The number of shares that we have does not change based on the amount of people we represent us at the meeting. So in order to affect change in your communities, you might have one vote, but if you know your next door neighbor never comes to these meetings, knock on their door, talk to them and say, hey, would you be willing to sign a proxy that gives me the authority to vote on your behalf? Then you're walking into the door to the meeting with 2 votes, and 2 votes is better than 1 vote in my opinion. And so that's another consideration. There's no restrictions on proxies, on the number of proxies that one person can have. I've heard reports of people walking into meetings with 75 proxies, and that's because they did the groundwork. They did the work out there on the ground. They knocked on doors and they got their neighbors. They shared their vision of the community with their neighbors, and their neighbors said, I like it. I like your style. I like what your priorities are. I'm willing to give you a proxy because I'm not able to come to the meeting myself. So doing that legwork is an important step for all of you to consider. Couple other questions here, Nick. Generally speaking, someone's asking, what's the role of the property manager during a meeting?
That's a good question. So that's going to be laid out in the contract between your association board of directors and that particular community association manager. So, oh, you're like, oh my goodness, there's a contract? Yes, actually there is a contract between those 2 parties. You as a homeowner have a right to request a copy of that contract. It is, off the top of my head, I believe it's House Bill 12-1237, if you wanted to grab a pen. But that bill explains what records the association is required to maintain and produce on request. And there's a nice little breakdown of which records are required to be produced, which may be produced at the discretion of the association. Now, I don't believe contracts is part of that, unless the contract is currently under negotiation. If it's a signed contract that's currently in effect, that has to be disclosed to the membership. And then lastly, records which may not be disclosed for disclosure. Sometimes I trip on my own words. So again, that's House Bill 12-1237 if you're interested. I hope that, so yeah, the role of the community manager, generally speaking, just to handle the everyday affairs of the association, like notifying people of potential violations, communicating with the homeowners. They organize the meetings. They make sure there's enough coffee available for everybody. I know you do more than that, but they handle the voting, the elections, the ballots. They do a lot, but you can see that in the contract specifically between your association and your manager.
Great. 2 quick questions that I'll not answer here. Can a homeowner give a board member a civility pledge to sign, or is a code of conduct a one-way street? That's an interesting question. Traditionally, we don't see that very often, but what we do see is in that governance policy that Nick mentioned, which is the conduct of meeting policy, there's usually a some language in those types of governance policies that talk about civility and talking about professionalism at these meetings, interrupting, yelling, foul language, all of these sorts of things. If you have those types of issues in your community, consider revisiting your conduct of meeting policy to include that. But it certainly is. It is a 2-way street. That's your board, how they behave, how your community association manager behaves, but certainly also includes how the homeowners behave as well. So keep that in mind. Another question here is, should homeowners be able to see minutes prior to the approval by the board of directors? Excellent question there, Kathy. As a general rule, homeowners do not have a right to see those until they have been approved, because the minutes could theoretically be changed until they are in fact approved. And there are even methods by which minutes could be amended or updated. What if we inadvertently mistakenly approved minutes that were inaccurate. We said we voted for something, but we didn't vote for something, or not in, or we said we voted in favor of something, but we actually just got a little confused and it was a typo. Minutes can be amended if necessary too, but the homeowners don't technically have a right to see a draft set of minutes, and it's a draft until it has been voted on by the board and approved. So hope that answers that question.
I could take one here. There's a question posed here. Can you confirm that violations and delinquencies can be talked about outside of an executive session? So yes, otherwise how else? Here, let me clarify that. Most likely you do not want to talk about specific homeowner violations or specific unit owner. You don't want to mention names. In other words, you don't want to say, oh, David down the street is delinquent $1,000 on his HOA dues. That most likely will not hold up too well in a court of law. But of course, in general, yes, I think the violations policy and the collections of unpaid assessments policy should definitely be talked about in any meeting, or in every meeting for that matter. Just as a friendly reminder, like, hey, if maybe the board just wants to inform the residents, if you're late on your assessment, this is what our policy says. So yeah, of course, generally speaking, they should be discussed.
Someone asked for the House bill, Nick, that you'd referred to regarding association records. That's House Bill 12-1237, which was codified into CCIOA at section 38-33.3-317. That's 317. So if you visit our website, download CCIOA from our website, scroll almost all the way to the bottom, section 317 will be right down there within the last 7-8 pages or thereabouts of the 85 pages that is CCIOA. So it was referenced House Bill 12-1237, or you can also find that codification of that that you are entitled to a copy of any contract, not just your management contract, as a homeowner. You can find that in section 317 of CCIOA.
If several agenda items are being voted on, do homeowners need to speak before each vote, or just before any voting is done? So no, they don't need to speak, but if they want to speak, they should be granted the opportunity to speak. How do you know if someone wants to speak or not? Maybe just ask, like, would anyone like to discuss before the board votes on this matter? Would anyone like to discuss this issue? And then wait, see if anyone wants to talk. I'm sure you might be surprised if you just pose that simple question. Now, importantly, before any voting is done, they should. How do I maybe rephrase this differently? If a unit owner is not granted the opportunity to speak before a vote occurs, there might be a problem there. Like if they want to talk and if somehow they're prevented from speaking, that could lead to issues.
Here's a very interesting question right towards the end here, Nick. We have mail-in ballots for board elections. Does sending in a ballot count towards quorum requirements, or is it explicit proxy required for that purpose, or they say in addition? I'll field that one because that's a good complicated question. I think that in most cases, voting by mail does not constitute attendance at a meeting for purposes of quorum. Attendance at a meeting is the only, or whether that's in person by yourself or by proxy, is the only way for you to count towards a quorum. Now, depending on how your board does things, they may not need to have a meeting in order for let's say we want to amend our governing documents. If they're amending their governing documents, they can arrange it so that votes are entirely by mail, and that a meeting is not necessarily scheduled for that. Now, the question is that all of you hopefully are thinking about in your head is what Nick just said a second ago. I have to have an opportunity to be heard before a vote. How do we do that if we are voting by mail? And there are different methods by which a board can satisfy that requirement. But maybe it's a public comment period, or not public, but a unit owner comment period, so that you can ask questions and better understand or share your thoughts or concerns about that amendment to the declaration in this example. So that's something important for board members out there to think about. If you are choosing to do voting by mail, it creates a litany of new complications that you wouldn't have if you simply said, okay, we're going to allow people to attend a meeting. We're going to allow everyone to talk at that meeting that would like to talk at that meeting, and then we will vote on whether or not we want to amend our documents, for instance. So some things to think about there.
Yeah, let me just follow up too on that, David. I would say the use of ballots is encouraged as a way to kind of garner more engagement or participation, just to kind of get the homeowners to vote or to participate. Sometimes they can't always make the meetings, like the evening board meetings or homeowner meetings, whatever. So if you mail out a ballot and have people vote that way, again, you have to make sure that, if they want to speak, they should be able to be heard on that. But as far as the content of that ballot, it might be a good idea to make sure any proposed rule or policy that you're thinking of amending or changing is clear, there's a clear definition of what it is that's currently in place and what the new rule will look like. Try not to make it vague, like say, mark I or mark no for changing policy 568.24 or whatever. Give as much information as you possibly can. That just goes along with being transparent with your community. I don't know about you, but if, when I look at a ballot, I want to know what it is I'm voting on, or at least I want the opportunity to look it up and do a little bit more research on what this means for me. But try your best to include as much information as you can on those ballots.
A couple more questions have come in regarding, particularly in regards to whether or not you as unit owners have the right to view contracts. In particular, a lot of these questions pertain to the management contract, but this is true for the roofing contract, the plumber contract, the electrician contract as well. Section 317 of Kiowa specifically says it has a long list of documents that as a unit owner you are entitled to viewing, to obtain a copy of. Now, your management company can charge you a reasonable fee for researching of documents or for copying. But you can also visit them and visit their offices and review these documents yourself. And then you wouldn't need to pay that fee to view these documents. But you are entitled to any contract that is currently in effect or that has been in effect in the last 2 years. So if someone wants to take a look at the contract between your board and your management company, for instance, you are entitled to doing that. On our website, we actually have a link to a form, which actually I'm going to go ahead and put it in the chat here. There's a template that our office has prepared. We don't provide templates the vast majority of the time but this template is something that is really not a legal document, and therefore it's permissible for us. We've prepared there. I just shot a link to a request form that a unit owner could utilize to request documents from whether you have a self-managed board or you have a professional management company that you would submit to. So, but what's important, and this goes to one of the questions that was asked, is who do I send that request to? How do I ask for a copy of the management contract? How do I ask for a copy of the minutes from 5 years ago? Whatever the case may be, both of which are things you're entitled to as unit owners. How do you do that? your documents, your governing documents may specifically have a policy or a procedure in place. I want you to be sure to follow that policy. It might say you have to send an email to XYZ email, or you have to send it to the CAM, your management manager specifically. I don't know what your documents say in that respect, so I can't tell you exactly. But if you don't, if your documents are silent, sending a request to your management company would be an excellent place to start. If they don't, if you don't hear back from them, could be a couple different reasons for that. Then I'd recommend attending a board meeting and saying, I requested these documents, I'm formally requesting them again. If you still do not receive a response, then probably your next escalation here would probably be to write a formal written letter, mail that letter with certified mail, return receipt requested to either your CAM or your board or both, asking for these documents. If documents that you are entitled to have not been produced in a timely manner, and that's according to statute, again, section 317, a unit owner is actually entitled to damages. You have to go to court to get those damages. You don't just get to say, well, you didn't give me the documents, so you owe me $50. You have to go to court, and a court may very likely should award you a penalty fee for their failure to provide documents that you are entitled to. That's in section 317, subsection 4.5. That's a pretty new law. That law became effective in 2022. So that's an important thing to consider. And I would suggest that you read that section of 317 carefully to make sure that you follow the timeliness and that you follow the procedures that are required by that law. Otherwise, a judge will say, you didn't do what you were supposed to do, unit owner, so I'm not going to award you anything. And I'm not, so you need to be mindful of that and make sure that you're following those directions carefully.
Yeah, just as a quick bonus topic here for those of you who have stuck around, here's a question, should homeowners have the opportunity to give input on the budget prior to the board of directors voting on it? So real quick, I'm just going to try and talk about the budget process in Colorado. So generally speaking, the board of directors adopts and approves a budget. Once that budget's approved, a meeting notice goes out in order to call a meeting within 90 days of that approval. At this meeting, the budget is automatically passed, so it does not require unit owner approval unless, keyword unless, the majority of unit owners present at that meeting, which have met the quorum requirement, veto that budget. Does that make sense? I hope that makes sense to everyone. Just waiting for a barrage of questions. Like, what do you mean? What do you mean? So yeah, that's, maybe we might do a HOA forum in the future on the budget process, and that would probably be a good one just to talk about budgets in general. But I was hoping to try and at least answer Kathy's question there. So in other words, yes, they should have the opportunity to give inputs on the budgets.
Nick, we actually
and if
did
that's
do
wrong,
a
you might want to veto it.
Sorry to interrupt you there, Nick. We did do a presentation on the budget process. I believe it might have been in October of 2022, and the laws have not changed since that time period. So the language that Nick just read to you all is still the controlling language there. So, any individuals that would be interested in that, it certainly is something that we will revisit and do a new presentation on at some point in the future. But we did do one not too long ago, so that and that information is still current. So you might want to take a gander at that, or at least take a look at the slides, and that would give you a good idea about that information.
Yeah, just as a reminder too, on the screen there, that's where you can go to see the recent HOA forums, just as a friendly reminder there. But yeah, any other questions? We really appreciate you guys attending these, and feel free to send us an email what your comments, remarks on these HOA forums, whether you find them helpful or not. If you had any suggestions, like, Nick don't talk as much or talk more or do more homework. I'm always open to feedback on presentations and whatnot. So feel free to send us an email. If you had questions in general, definitely send it to Dora_Dre. And again, that's actually HOA inquiries, plural, inquiries, plural. So when you're trying to compose an email, make sure you include the extra I and the extra S, because sometimes people misspell that. So yeah, again, thank you so much, everybody, for attending.
Nick, if I may interrupt you one last time here, and I do apologize, I'm going to put one bit of important information in an individual just asked about a bill that was passed by the legislature this year. It was actually signed by the governor just on the 24th of May. And what this bill does is it creates 2 task forces. And these task forces are, one of those task forces pertains to homeowners associations, homeowner rights in particular. And then the second is metropolitan district. It's a metropolitan district homeowners task force, rights task force, and both of these are in the midst of being created at present. And I'm going to, for anyone that is interested in participating in this task force process as a member of these task forces, I recommend that you take a look at these at the links that I'm putting into the chat right now. If I can, I'm going to have to do it. I'm having a hard time copying and pasting right now. I apologize. Maybe it's because my message is too long. Here is the first one I just entered into the chat. Is if you are interested in being on the HOA task force for either as a homeowner or a representative of an organization that advocates for HOA homeowners in Colorado, or as an attorney who specializes in representing homeowners in legal matters. This first link that I've put in here is for you. That is an application process. That the appointing authority for these positions is the chairperson of the House of Representatives. There are a few other positions, which I'm going to put into the chat now, which are appointed by a second appointing authority, and that's the governor of the state of Colorado. And the governor's office will be appointing a Colorado attorney that specializes in CIC law. Generally speaking, another way to look at that is an attorney that would represent a board in transactional or litigation matters, or a representative of a developer, or an accredited community association manager. And I know from Nick's question earlier, we've got a couple cams on this meeting right now. So if you fit into one of those 3 departments or three categories, and you're interested in maybe serving on this board, or excuse me, this task force, you take a look at the second link that I have in the chat here, and you can fill out the application process there for 1105. Outside of those steps for right now, no doubt the HOA Center will have more information on these task forces as they are appointed, the members of the task forces are appointed, and as we are scheduling meetings for the future. Certainly, we are very interested. We want to encourage people from all walks of life, condominiums, ranches, property owners associations, co-ops, and we want geographic participation. I want people from Dolores, Colorado, and from Fort Collins, and from Pueblo, and the mountain towns like Keystone and Vail. We would really like to have as much participation from all walks of life and all parts of the state, and all different types of communities to participate through the public comment period in these task force meetings. So stay tuned for more information on those as we are moving forward, and stay tuned also for Nick mentioned that next month we will be doing a legislative update forum that will pertain to the bills that were passed during the 2023 legislative session. So stay tuned for information on that in the near future as well.
Awesome. All right, guys. Well, we're going to bid you farewell. We hope everybody has a great weekend. Go Nuggets. That was a pretty exciting parade that we had yesterday. And again, thank you very much for attending, and stay tuned for our future HOA forums. And here's a quick sneak peek. We're going to try and do one with a local law firm, hopefully in August. We'll see if we can get a couple of attorneys to come in and kind of share their experience with us, and just in general, how they view homeowner associations and all the issues and disputes that sometimes arise. So stay tuned, and thanks again. I hope everybody has a great weekend. All right, bye-bye.